Welcome to part 2 of the SIAC and JAA Kansai chapter Osaka webinar series. SIAC is delighted to be co-hosting this webinar with the Kansai chapter of the Japan Association of Arbitrators, or the JAA. Thank you all for joining us today from all over the world. My name is Michelle Sonin, and I am the head of Northeast Asia at SIAC, and I will be your MC and moderator this afternoon. Today's webinar is entitled Negotiations to Constitution of the Arbitral Tribunal, a practical guide to preparing for arbitration. We will be looking at some of the strategic choices that parties make when negotiating arbitration agreements and at the outset of a dispute. And many of these choices, as we'll hear from our panelists, can have lasting consequences on a dispute. Before we start the discussion, SIAC and JAA will be giving brief welcome remarks. At this time, I would like to invite my colleague, Mr. Kevin Nash, Deputy Registrar and Center Director of SIAC, to welcome you on behalf of SIAC. Kevin, please.
Thank you, Michelle. Mr. Okada, President of the JAA, Mr. Kodama, Chair of the Kansai chapter of the JAA, panelists, attendees, good afternoon. Thank you for joining us today for this webinar co-hosted by SIAC and the JAA. This webinar is part 2 of a series that is tailored for Japanese companies in Osaka and the Kansai region. We are delighted to be co-hosting with the Kansai chapter of the JAA, and we would like to express our appreciation to the Kansai chapter for its efforts in organizing these webinars. SIAC is fortunate to have worked with our friends at the JAA on several occasions throughout the years. SIAC and the JAA entered into a memorandum of understanding to promote international arbitration as the preferred method of dispute resolution for resolving international disputes. And we have jointly hosted many events in Japan, like today's webinar, that provide insights and practical guidance on international arbitration at SIAC. The Kansai region is the center of much of Japan's international business, including international trade and investment by large companies and SMEs based in the region. In today's globalized world, it is important for companies to have access to a dispute resolution mechanism that meets the unique needs of international business. International arbitration has proven to be perfectly suited to meet those needs by providing flexibility, confidentiality, party autonomy, efficiency, enforceability, finality, among other benefits. As the gatekeeper to the arbitral process, SIAC plays an important role in ensuring that arbitration meets the needs of the business community. We are constantly seeking to enhance the user experience by ensuring speed, quality, efficiency, and a personal level of service in case management. Japanese parties are valued top users of SIAC. Japanese top trading parties are also among SIAC's top foreign users: China, the United States, Vietnam, to name a few. Today's webinar will focus specifically on key steps and strategies when preparing for an arbitration. These are important issues that can have lasting consequences on the dispute and the parties' business relationship. We have an excellent panel of practitioners experienced in both Japan and Singapore who will be sharing their experience with you today. From a secretariat standpoint, with experience in thousands of cases, we certainly see firsthand the importance of being prepared for an arbitration. This includes drafting an effective and valid arbitration clause, the getting up prior to commencing arbitration, such as document management and asset tracing, and utilizing the procedural mechanisms under the SIAC rules prior to the constitution of the tribunal, such as emergency arbitration, prima facie jurisdictional objections, expedited procedure, consolidation, and joinder. I would like to thank our speakers and our supporting organizations for your time and contributions. I wish everyone an enjoyable and productive webinar. Thank you.
Thank you, Kevin. I would now like to invite Mr. Haruo Okada, President of the JAA, to give his remarks. Haruo, please.
Thank you for the introduction. I am Haruo Okada, the President of Japan Association of Arbitrators, JAA. I am very honored to be able to co-host such a valuable webinar through our Kansai chapter today. Arbitrations and mediations are called ADR, Alternative Dispute Resolution. Why is it called alternative? That is, alternative to litigation. However, as for international disputes, ADR is now a mainstream dispute resolution. Some people say now ADR stands for Appropriate Dispute Resolution, ADR. What an appropriate explanation for present status of ADRs. Under the corona epidemic, lockdowns and travel restrictions in various countries have made it difficult to conduct face-to-face proceedings. The method of conducting a litigation is determined by the laws of each country and not so flexible, thereby has undergone several setbacks under the corona epidemic. On the other hand, the advantage of ADR is the flexibility of the parties to decide the procedures by agreement. Due to the flexibility of the procedures, ADRs are proceeding without setback, even under the corona epidemic, through online only or hybrid of online and face-to-face procedures. Arbitrators and mediators, as well as ADR's institutions, are getting used to online procedures and accumulating techniques and know-how for online procedures. In addition, the parties are becoming accustomed to online proceedings. It is not an exaggeration at all to say ADRs have undergone evolution to a higher stage or dimension of dispute resolution during and after corona epidemic. In this way, ADRs are now becoming more and more mainstream and appropriate procedures. Let me introduce another important and latest developments concerning ADRs, that is combined use of mediation and arbitration. Mediation and arbitration are not either or, but work together. Such combined use of arbitration and mediation, such as mid-herb, to mediate first, if not successful, then to go to arbitration, may compensate for each other's shortcomings. Thus, currently, such combined use of mediation and arbitration is in the spotlight globally. In this connection, I'd like to introduce Japan International Mediation Center in Kyoto, JIMIC, established and administered by JAA. Especially in case of international commercial disputes between Japan and another country, the combined use of JIMIC mediation and SIAC arbitration may be worth considering. In order to promote and enhance such use under the corona epidemic, JAA entered into a joint protocol for cooperation between JIMIC and Singapore International Mediation Center, sister institution of SIAC. I hope this combined usage may be referred to during today's webinar. In collaboration with SIAC and Kansai chapter of JAA, this webinar will provide practical guidance specifically to small or medium-sized enterprises in Japan for using ADRs. Experienced practitioners will discuss strategic consideration with respect to important issues. This is a very valuable opportunity, and we do hope all of you watching today's webinar will grasp a better and clearer view as to how to use ADRs effectively. Thank you for your attention.
Thank you very much, Haruo. We will now move on to the panel discussion, and I am delighted to introduce our panelists. Joining us today are Mr. Masafumi Kodama, Chair of the Kansai chapter of the JAA and partner at Kidohama Partners, Mr. Kazuhiro Kobayashi, Vice Chair of the Kansai chapter of the JAA and partner at Oebashi LLPC and Partners, Ms. Jill Anko, partner at Wong Partnership, and Ms. Elaine Wong, partner at Herbert Smith Freehills. I will be moderating the discussion today. Thank you everyone for joining us. We're going to be covering quite a bit of ground today, and we're going to discuss 4 broad topics: drafting arbitration agreements, settlement negotiations, nominating arbitrators, and applications that would be made in an arbitration before an arbitral tribunal is constituted. If during the course of this webinar you have any questions, please feel free to ask them using the Q&A button at the bottom of your screen. We will reserve about 15 minutes at the end of this webinar to answer your questions. So let's get started with topic 1, drafting arbitration agreements. One of the most common questions that I've received in my time as head of Northeast Asia at SIAC is to provide clarity on the seat, the arbitral seat, and also how that connects to the venue of the arbitration. People often ask for what are the differences and what are the considerations that I should consider when selecting an arbitral seat. So to kick off this webinar, I'm going to turn to Jill to give us a quick overview of seat and venue and tell us why they matter in your cases. Jill?
Good afternoon, everyone. Thank you for having me on the panel today. On your question, Michelle, perhaps I can start by posing a question first. So we may come across an arbitration clause that says parties agree to submit their disputes to arbitration in Japan or arbitration to be held in Osaka. Is this a reference to Japan as the seat of the arbitration or Japan as the venue? And what is the difference? Well, I think most of you can guess. The seat and the venue of the arbitration refers to two different things. The seat, also known as the place of the arbitration, is the legal home of the arbitration, while venue refers to the physical and geographic location that the arbitration meetings and hearings will take place. The two may end up in the same place, but that's not always the case. Now, deciding the seat has important legal effects. It is the law of the seat that will determine the grounds on which an award can be challenged before local courts. And such grounds may be limited or they may be very broad and give the courts quite wide powers to reopen the merits of the dispute. It is important to then choose a seat in an arbitration-friendly jurisdiction with a reputation for enforcing arbitration agreements and awards and with neutral and impartial courts. The law of the seat also regulates possible recourse that the parties may have to the courts in respect of the arbitration. So, for example, parties should consider whether the law of the seat provides for enforcement of interim measures that have been granted by the tribunal, or whether the courts grant interim measures, in support of the arbitration, perhaps even before arbitration proceedings commence. And because an arbitration award is made in a country that is party to the New York Convention, is recognized and enforced in all New York Convention countries worldwide, as a general rule, parties should set the seat of arbitration in a New York Convention country. On the other hand, the venue or venues where an arbitration may be held has far less significance. So the choice of venue is likely to be motivated by less serious circumstances, less significant considerations, such as cost, logistical convenience, practicalities like, is it in an appropriate time zone that would suit the arbitrators, the parties, and the witnesses? And also, the seat, the venue, unlike the seat, can actually change as the arbitration moves along. So there can be multiple different venues, or, as Mr. Okada mentioned in his opening speech, a lot of it now is over virtual hearings. So it is not common actually for parties to specify in the arbitration agreement the venue, and it's certainly not essential that they do so. So if I can go back to the question I asked earlier, when an arbitration agreement states that the arbitration is to be held in Japan, what is that likely to be a reference to? Well, I can't say that this is the approach that the courts of all other jurisdictions will take, but this was a case that was considered by the Court of Appeal in Singapore recently, and the court found that because the seat has a much larger legal significance as compared to that of the venue, when parties only specify one place in the arbitration agreement, that is very likely to be a reference to the seat and not the venue.
Thanks so much, Jill. As a quick follow-up question, in the most recent Queen Mary University of London International Arbitration Survey, Singapore was jointly ranked with London as the most preferred arbitral seat. In just a minute or two, do you think you can give us a few quick highlights of why Singapore is such a preferred arbitral seat?
Well, there are a few reasons. I can just mention a few. One of it is that Singapore is seen as a neutral jurisdiction. And I mentioned because of the significance of the seat and the implications that this has on the arbitral process, parties often want to choose somewhere that's neutral and doesn't offer a home advantage to one party or the other. The second reason is the very strong pro-arbitration commitment on the part of courts. And that's evident in, for example, the court's willingness to grant interim measures, its very strong policy of minimal judicial intervention when it comes to considering setting aside applications. So parties can be rest assured that courts will strive to uphold an arbitral award that's made in Singapore. Another reason is, Singapore has a very highly evolved arbitration law framework that is quick to adapt to the needs of arbitration users. So its International Arbitration Act is constantly being amended to take into account, the needs of arbitration users. And the fourth reason, and this is not because I'm on a SIAC webinar, but it has a very strong arbitral institution in the form of the SIAC, which administers arbitrations in Singapore.
Thank you, Jill. If I could actually turn to Masafumi next, because as many of you may know, Osaka fairly recently opened up the Japan International Dispute Resolution Center, or the JIDRC. And maybe Masafumi, could you tell us a little bit more about the JIDRC's role in Osaka and what parties could expect if they were to arbitrate in Osaka?
Thank you. Well, JDLC now operates one hearing facility in Osaka. It's a very convenient place and well equipped for the on-site or remote hearing as well. And JDLC is also bearing the role to promote arbitration generally in Japan. JDLC is holding various seminars and signing MOUs with various institutions, including SIAC, to conduct arbitration hearing in Japan as well.
Great, thank you. Let's move on to the next topic, but still staying within the broad theme of negotiating arbitration agreements. Arbitral institution. The selection of an arbitral institution is another important choice that's going to be made in an arbitration clause. And I say that not just because I am a representative of the SIAC, but maybe I could invite Kazuhiro to shed some light on what the role of an institution is and what parties, in particular parties based in Osaka, should be thinking about when they are selecting an institution and including the institution in their arbitration clause.
Thank you, Michelle. Good afternoon, everybody. Although that many foreigners are actually watching this webinar, I'd like to talk about it from the perspective of Japanese companies and also from the practical point of view. Firstly, that as you know, that there are two kinds of arbitrations. One is ad hoc arbitration, and the other is the institutional arbitration. And I think that in case of ad hoc arbitrations, the parties and arbitrators do much more work than in case of the arbitral institution. They have to do what the arbitration institution should do. So I don't think that Japanese companies should choose ad hoc institution because Japanese companies do not have much experience of arbitration. So I think the Japanese companies should try rely on the arbitral institution. For instance, that what arbitration institutions do is depending on the each arbitral institution, but the institutional usually provide that their rules of arbitration. So the party do not have to prepare detailed rules of procedure in the agreement. But although they can choose like ancillary arbitration rule. In addition, I have some, I believe that some countries do not allow ad hoc arbitration in their countries. I think that China is one of them. So in that case, you cannot hold ad hoc arbitration in China. And then nextly, that which arbitration should the party choose? Practically speaking, I think that the party should choose arbitral institution when it's seated in the place of arbitration. Although Jill explained that there is a difference between the seat and the venue, but I like to, practically speak, I like to choose that basically place of the arbitration institution of the place of the arbitration. But nevertheless, that there are some, especially Asian countries, that don't have the good arbitral institution. So I think in that case, we should consider choosing that the SIAC, Singapore International Arbitration Center, instead of such a local arbitration institution. I'd like to discuss more later about regarding the appointment arbitrators or something like that later. Thank you.
Sure. Thank you for that. Yeah, just to elaborate a little bit more, some of the services that institutions like SIAC provide, is handling the financial management of the case. SIAC also provides a scrutiny process where we will review draft awards to help enhance enforceability. So it just help ensure that there are limited error, help avoid errors. So we're not going to be looking at the merits of the case, but just looking at the form and so forth to help with the avoidance of errors. Okay, thank you very much for that, Kazuhiro. Let us move on to the applicable laws. So another important part of an arbitration agreement, or really, important part of the negotiations of any contract is deciding what law will govern the substantive dispute, any disputes that arise out of the agreement, but then also what law would govern the arbitration agreement. And many parties often don't know that, in fact, this can be different. So I will ask Elaine to come in and sort of explain to us what the different types of applicable laws are and what their implications are, and then also sort of the different considerations that you're going to be looking at when you've got, substantive law versus law of the arbitration agreement and so forth. Elaine?
Thanks for the question, Michelle. That's a really interesting topic. So arbitration is a bit different from court litigation in this respect. You might find that you have to grapple with different bodies of law. And so the three key ones that we want to talk about today are the governing law of the contract. So, that's what you see very often in your contract. At the end, there's a little clause that says, this contract should be governed by the laws of Japan or Singapore or whatever. And I think most people understand that that deals with the substantive rights and obligations of the parties under the contract that they have signed. Then the next law that we should talk about is the law of the arbitration agreement. So even though your arbitration agreement is most commonly found in the arbitration clause, which is also part of the main body of the contract, often right at the end, it is considered in most jurisdictions as a separate agreement. So it's possible to have a separate law that governs just the arbitration clause. Why is this relevant at all? Why does anyone care what the law of the arbitration agreement is? It comes into play in certain circumstances. So for example, if there's a dispute as to whether an agreement was reached between the parties to arbitrate, if there's any contention between the parties as to the enforceability of the clause or the scope of the clause. So that's why it's relevant to think about the law of the arbitration agreement. And then the third law that we need to bear in mind is the law of the seat. And so I think my fellow panelists have already touched on this topic, but that is the law of the place where you've chosen to seat the arbitration. And that has an impact first on any potential enforcement of the award. It also has an impact on the procedure of the arbitration. So what happens is that the procedure of the arbitration, and by that I mean things like how will it be conducted? How is an arbitral tribunal to be constituted? How do we gather evidence? Things like that. So issues that don't relate to the rights and obligations of the party per se, but how we should conduct the arbitration itself, that arises from the law of the seat. And as Michelle asked, do all three need to be the same? They can be, but they don't have to be. So in a lot of contracts, it is very consistent. People would choose, let's call it governing laws, Japanese law, seat of the arbitration, maybe Osaka or Tokyo. And so it's quite consistent across the board. But you don't have to do that. I have seen and been involved in disputes which have contracts which are, say, governed by Japanese law, but the seat of the arbitration is Singapore, or it can be the reverse. So it can be an arbitration seated in Japan, but the governing law is Singapore law. From the perspective of someone who practices international arbitration and also sits as an arbitrator, it doesn't matter to me. I don't think one is better or the other. I don't think it's better to have them all the same, or it's better to have different seats versus governing law. It all depends on the circumstances of your case. And it can be a complex issue. So if you're confused about it, it probably bears the opportunity to have a consultation with your advisors. But I think from my perspective, what would be useful is to keep in mind that certain jurisdictions are, as we've said, less arbitration friendly. So in that case, you may not want to have the seat of the arbitration as that particular country, because you might run into issues if you need support for the arbitration, whether it's a constitution of the tribunal, whether it's an issue as regards enforceability after the award is rendered. But then it might be that it makes most commercial sense to choose the governing law as the law where the contract is actually going to be performed. So to give an example, many people say you enter into a construction contract and you need to build something in a developing country. You might agree to use the law of that country just because it makes sense for the project. And in certain countries, there are mandatory rules. So you might be obliged to choose certain laws for certain projects. In that case, it's fine. You can have that as the governing law, but then you might want to have a different seat of the arbitration. So really, there are quite a number of issues at play, and I think it really just depends on the complexity of your project, which are the jurisdictions you're considering. But I would say that by and large, we should ensure that the seat of the arbitration is one that you're comfortable with. So if you ever run into any issue, you know that it's a system of law that you can grapple with, or you can get help by instructing counsel that you know would be able to help.
Thanks, Elaine. One follow-up question, when let's say you're about to start a dispute and you've got, just to take an example, the governing law being the substantive governing law being Japanese law, and let's say the seat and the arbitration agreement would be Singapore, something like just some combination where it's not the same. Should that influence your choice of attorneys? Does it make, do you need to sort of get co-counsel where you've got, each law covered, or how do you sort of handle that issue?
Yeah, so I mean, we have that issue very often. So for example, my firm's an international firm, so we have offices around the world. We're not necessarily able to practice local law in every country, because obviously there are regulations that we need to abide by. So in a case where it involves multiple jurisdictions, yes, we often do co-counsel. It depends on the issues at stake. We do have familiarity with different bodies of law. So for some laws, I think we're quite comfortable to just deal with it ourselves. In other respects, we might think, I know it's better to have some differentiation or have local counsel to make sure that we cover all the legal points. Another consideration is your tribunal. So it depends on whether your arbitrators are well-versed in the law that they need to apply. And so that all has a bearing on the strategy, and it really depends, I think, on a number of factors. But it's not an impediment to running an efficient and successful arbitration. It's just another thing to think about.
Sure. Anybody else want to chime in on this topic, or shall we go ahead and move on to the next one?
Yeah, maybe I'd like to discuss later the appointment of the arbitrator. I believe that the SIAC had that list of arbitrators, the arbitrator who can know the Japanese law, right?
Yeah. As in, we will talk. Let's go ahead and include this in the discussion of nominating arbitrators in the next section. But yes, SIAC does have a panel of arbitrators that is published on the SIAC website. But let's put a dog ear there and come back to that in a few moments. Okay, so our last topic under the broad topic of drafting arbitration agreements is hybrid mechanisms and tiered clauses. I think to some of you that might sound like gibberish. What is a hybrid mechanism and a tiered clause? But I think once our speakers provide some context, you'll actually think that it does sound quite familiar. So if I could invite Jill to come in first and just give us sort of an overview of tiered clauses and hybrid, and when you might consider using one, and what are the sort of drawbacks or cautions that we need to think about.
Thanks, Michelle. So a multi-tiered arbitration clause is a clause by which parties can agree to alternative ways to resolve their dispute amicably before parties choose to resort to arbitration. So a simple clause like that could be where parties agree that they would first attempt good faith negotiations or discussions to resolve their dispute, and only to refer the dispute to arbitration if, say, no resolution is reached within 30 days. For example. Or it could be something a lot more detailed and provide that, in a dispute between the parties will first be referred to a meeting between, say, the project managers. Failing that, it goes to senior management, and failing that, parties can then resort to arbitration. Some of the merits and drawbacks and when it might be used more often. Merits, if it succeeds in avoiding arbitration, of course, it's cost efficient, it's time efficient, it helps to preserve business relationships. So I personally find that a clause like that might be more useful when contracting parties are in a very long-standing, business relationship, and they feel that, amicable discussions is something that's more likely to bear fruit for them. But even if parties don't still end up in arbitration eventually, these negotiations could possibly help to narrow the issues in dispute. There are drawbacks, however, and it is because parties need to fulfill each step before arbitration is commenced. So these clauses tend to delay the commencement of arbitration and would be a waste of time and money if there is a sense that, settlement negotiations are unlikely to succeed. So sometimes you might come across a case where parties feel that they are just superficially going through each step when their ultimate goal in mind is just to commence arbitration anyway. And then even after arbitration is commenced, time could be spent during the arbitration, arguing on whether parties have properly complied with each step of the clause, which can also result in, jurisdictional objections being raised.
Great, thank you, Jill. So one very popular variation on this sort of tiered clause that requires negotiation would be a hybrid mechanism that actually incorporates mediation into the dispute resolution mechanism. So I'm going to ask Masafumi if you could talk to us a little bit about our mid-arb and med-arb, and specifically the types of hybrid mechanisms that combine arbitration and mediation.
Okay, thank you. Well, ARB-med is basically mid-arb is basically you have to mediate first before you go to arbitration. And ARB-med-arb is something that you start arbitration first and then mediate, then go back to arbitration if settlement agreement is not reached. The good thing for mid-arb is just as Jill described. You may reach a settlement and save time and cost, or you may narrow down the issues even if you don't reach an agreement. And the virtue of ARB-med-arb may be about the enforcement of the settlement agreement, especially in the country like Japan, where the country does not ratify the Singapore Mediation Convention. If Singapore Mediation Convention is ratified, then a settlement agreement can be enforceable. Otherwise, often settlement agreement can be enforced by virtue of making into arbitral award or consent award by the parties. Consent by the parties can be made into arbitral awards. But the risk is that if the arbitration is initiated after you reach an agreement, then there's risk that the arbitral award is obtained where there's no dispute, no genuine dispute, and then the arbitral award may not be enforceable. To avoid that risk, I think it would be prudent to have arb-med-arb clause. Thank you.
Yeah, that's great. Yeah, just to elaborate a little bit more. So SIAC actually does have a arb-med-arb protocol with the Singapore Mediation Center. And under this protocol, what would happen is you would start the arbitration at SIAC, and then you would sort of put a pause in it and then go over to the SIMC to do the mediation. And then when the mediation is complete, you would come back to SIAC. At that point, you could get a consent award, which allows the settlement agreement to be enforced like an arbitral award, or you would just continue your arbitration if you weren't able to reach settlement. So this is specifically SIAC, SIMC protocol, but you can of course do arb-med-arb using other mediation institutions as well. And as Mr. Okada mentioned in his welcome remarks, there's the Japan International Mediation Center, JIMC, located in Kyoto. You know, so you're really able, the beauty of arbitration, international mediation is the flexibility, right? So you can sort of use SIAC, you could use JIMC, you could use SIMC, and so forth to sort of build a mechanism that's going to best suit your case. Okay, enough from the moderator. Let's move on to the next topic. So we've sort of wrapped up drafting negotiation agreements, our first broad topic, and let's now move into our second broad topic, settlement negotiations. Specifically, what strategic considerations come into play when you're trying to negotiate a settlement? So let's, I'm gonna, toss this over to Kazuhiro. What advice do you give to your Japanese parties when engaging in settlement negotiations?
Well, generally speaking, that the Japanese company would not like to settle dispute in the legal proceeding, such as litigation or arbitration. They would like to settle dispute by negotiation. In case of domestic dispute, Japanese company do so partly because they consider much more continuing business relationship, or partly because of the their bargaining powers between the parties, or partly because that the domestic agreements are not so detailed than in the international agreements, and so they don't care more the legal issues, or that's the situation. But recently, so that's why the Japanese company tend to ask for counsels and later than the foreign company, I think. But these days, that the listed companies, in Japanese listed companies, become to avoid the settlement out of the court, considering that the shareholders' interest. But in case of the international arbitration, Japanese company tend to stick to that negotiation more than the domestic arbitration. I think that is because that they are not familiar with international litigation arbitration than the domestic litigation. Also, partly because they do not trust that such international arbitration litigation than the Japanese court. So that's why also that the Japanese company also do not like to spend much more money in international disputes. They like to spend much money in the new business and new deals, and so they like to settle that the disputes without legal proceeding. But I don't think that in case of the foreign dispute, that the foreign companies would not like to settle so easily with Japanese companies. So I think Japanese companies tend to ask for Japanese counsel earlier than in case of the arbitration, international dispute than the domestic disputes. I have I had one experience that the representing foreign companies owned subsidiary in Japan and negotiating with Japanese company. This case is a little bit complicated and I cannot disclose detail, but there are two agreements. The first one is prepared by Japanese companies and written in Japanese, and the dispute resolution clause was in the litigation Tokyo District Court. The second agreement was prepared by the foreign subsidiary and written in the English language, and the dispute resolution clause was arbitration and SIAC rules in Tokyo. And at first that the Japanese companies are not comfortable with that the foreign subsidiary service, and they demand a huge amount of damages, such as similarly the attitude with the Japanese other suppliers. But once we were appointed by attorney for such a foreign subsidiary, Japanese company also appointed Japanese lawyer for other counsel, and such Japanese lawyer can understand that the issues like such as the agreement issues, because that the basic disputes are much more related to the second agreement and the because of the SIAC rules in Tokyo. So finally, the Japanese company understand the situation. They agree that the settlement, like by the 1/10 of the amount that they first claimed that year. So considering the point of that year, I think that the Japanese company should try to ask for Japanese company much more earlier than the domestic dispute. And also from the case that I think that the foreign company should think of the considering such a dispute resolution clause, the arbitration and the SIAC rules in Tokyo, Osaka. Thank you.
Great, thank you. Thank you for that sort of case study, and I'm glad to hear that there was a positive outcome for all the parties. And I also think it's interesting insights in terms of sort of getting counsel involved early to start the discussion. Elaine, you have also have a lot of experience representing Japanese companies. Is there anything that you would add to that?
Yeah, I mean, I lived and worked in Japan from 2010 to 2019, and during that period, I think I saw a bit of a trend towards increased familiarity by the Japanese corporates with international arbitration. So I think that for a lot of companies, they're more aware of how arbitration works. They're more comfortable with getting involved in an international arbitration. So a lot of people, I think, might have a perception of Japanese companies as averse to arbitration, litigation. They don't want to get involved at all. That they want to make sure that they negotiate and settle all of their claims. But I think that in the right situation, and obviously with the right company, Japanese corporates these days are very much happy to engage in an international arbitration and even act as a claimant. They don't necessarily wait to be served with the proceedings. But I think what is important to bear in mind is what you want out of the arbitration. So for some parties, it's a question of showing the other side that they're not going to accept a breach of their contract, that there are principles involved, and they need to send a strong message that they don't want those rights to be violated. For others, it's just a question of money. I want to recover X amount, and it's just what the company's management has told me, go out and recover these amounts of money. It's usually a mixture of both, right? And I think that parties are now more aware that arbitration is often a step towards getting the settlement amount that you want. So yes, you may not want to have an arbitration procedure that goes all the way to the end. You don't want to have to spend lots of money and time managing an arbitration and paying for lawyers to deal with it. But it is quite often the case that in order to be taken seriously by an aggressive counterparty, you might have to commence proceedings. And so we use the notice of arbitration or even the first statement of case as a means to put down in writing what your case is and why you think the other side is in the wrong and why they need to compensate you or whatever your claim is. And then with that, you have a better chance of securing a settlement offer that's favorable to you. So there are a lot of issues at stake here. So, what I've already touched on the topic of timing. That is one of the good times at which you might expect to reach a settlement agreement. So maybe when you commence proceedings, maybe when you put in the notice of arbitration, maybe when you first file your memorial, which includes very often witness statements, expert reports. So you show the other side how strong a case you have. You can settle at any time. So even if you have a hearing fixed, the tribunal is ready, you've got all your hearing bundles ready, your lawyers have done the prep. If you feel that there's a right time to settle and you get an offer that is what you want, then yes, it might very well be good to just accept it, because no matter how strong your case is, obviously there's a risk in any dispute that the tribunal may not find in favor of your case. Another question people ask, how do we conduct these settlement negotiations? What are the practicalities involved? Do we do it on our own? Do we ask our lawyers to conduct the negotiations for us? I think what I commonly see would be that the senior management at the two companies will usually talk to each other. It depends whether you want to get the head of legal involved, or sometimes it's the CFOs, because maybe it's a financial matter, or maybe the CEOs, they get together and they try to come up with an agreement to settle the differences. Obviously, if that works, that's best for everyone. At a later stage, you might want to involve your lawyers. So very often we see that we get asked to attend settlement meetings towards the end when more issues have already been resolved and we are working out the practicalities and the legal issues. But on the other hand, I've also done settlement negotiations entirely on our own without the clients. So it really depends on the dispute at hand. It depends on the nature of your counterparty. It depends on who they feel to these negotiation meetings. So you must always ask who's going to attend. Is it going to be a senior person? Are they going to bring your lawyers? Things like that. So a whole bunch of things to think about. And one last thought to leave with you. If your dispute is very complicated, and hopefully, yours is a fairly straightforward case, but if it's very complicated, there are many different factors which may affect the likelihood of success. So to give you an example, I spent all this morning working on what we call a decision tree analysis. And that what it does is that it calculates the chances of our clients winning in the arbitration. And we need to do that because it involves breaches in different years. So, we could win in 1 year, but we could lose in the next year, or we could win again in the third year. And then there are many different factors at play. Has there been a breach? If there's been a breach, is there actually causation? There are limitations of liability. Do they apply? So if my client were to ask me, are we going to win? I can't just pluck a number out of the air and go, yeah, I think so. 90% chance you win. This is a bit more scientific, and so it's quite fun, really. So, we discuss it, we apply the law to the facts, and then we try to put in different probabilities for different issues, and then we come up with a figure at the end, and we use that to guide our clients so that they know what they can expect if they go through the arbitration procedure, and obviously then they can decide how they want to conduct their settlement negotiations.
Thank you, Elaine. All very interesting stuff. I love the heavy use of statistics and mathematics to sort of inform settlement negotiations. before we move on to the next topic, and I think this is a really interesting topic, so we'll give it a couple of more minutes. I wanted to turn to Masafumi because in our sort of pre-webinar discussion, he raised some good points about having settlement discussions without prejudice and what that means. So Masafumi, could I invite you to share your thoughts on that?
Thank you. Well, we are often proposed to negotiate without prejudice from the parties in common law countries like Singapore, US, or UK. But we, Japanese or civil law-based companies, are not familiar with that. And I'm often asked by my Japanese clients to explain the meaning of that. So I thought that this might be a good opportunity to explain. This is very simple. You cannot use what you discussed in the negotiation in the subsequent litigation or arbitration. Generally, without prejudice negotiation would increase the chance that the parties would be more frank and make more bold or big compromise. So generally speaking, I would recommend to accept the proposal to negotiate without prejudice. Thank you.
Thank you for that. Okay, clock is ticking, so let's move on. All right, I'd like to move on to our next broad topic, which is on the nomination of arbitrators. And specifically, what is the process for nominating arbitrators? And perhaps more importantly, what are the considerations that parties need to keep in mind when they are appointing or nominating arbitrators to resolve their disputes? And I will turn to Kazuhiro to give us some thoughts on this.
Thank you, Michelle. I'd like to talk from also the Japanese perspective, company's perspectives too. I think depending on the rules of arbitral institution, I believe that the party can agree on the way to choose arbitrators, but I think that it is safer for the Japanese company to stick to the rules of arbitral institution to avoid for the risk of the validity of arbitral agreement. And generally speaking, I think that in case of 3 arbitrators arbitration, each party can appoint 1 arbitrator, and then such a party appointed arbitrators choose the 3rd arbitrators. In case of the sole arbitrators arbitration, the parties may agree to choose such a sole arbitrator, but if they cannot agree, the arbitral institution choose the arbitrator. Under the rules of the certain arbitral institution, that the parties have to choose the arbitrator from the list of the arbitrators. In that case, the list is very important. I skip actually the reason that I should say that you should choose that the arbitral institution that which is seated in the place of arbitration, because that basically such local arbitral institution has that list of the arbitrators resident in that such local area. If the parties choose that the arbitrator outside that such a place, the party have to pay that the bear cost of the travel and accommodations or something like that, even though that recently that the remote or web arbitration is very common and popular in the under the COVID-19 pandemic. But that's why I think that the reason the choose that the local arbitral institution. But nevertheless, that even if that the parties do not have to choose arbitrator from the list, I think that list is important, because that I assume that the listed people should know the rules of arbitral institution, at least some part. So that's why that the list is very important. That's why that I think that in case of the local arbitration, arbitral institution is not good for enough, that we should consider that choosing that the SIAC instead of such a local arbitration because of that the list of the SIAC. And I think that the as I said, the Japanese companies' cultures are a little bit different from the foreign companies, such as attitude of the negotiations or including Japanese language. So I think the Japanese company would like to choose arbitrators who can understand such cultures. So in case of the 3 arbitrations, Japanese companies should try to choose such arbitrators. Therefore, it is very important to pick up that the list of arbitrators, as I said before, that the SIC has the arbitrators who can understand Japanese law or who can speak Japanese in the list. So, but in case of the sole arbitrator, it is very difficult for the Japanese company to choose that kind of the arbitrator. So it is very important to pick up that the fair arbitrators who can at least that the what the Japanese company argues listen. That's important. But as I pick up to that the such a local bad arbitral institution, they don't have much experience to appoint such a fair arbitrators, or they don't have the list of the contain such a fair arbitrator. So in that case, I think we should consider that the SIAC arbitration institution. Thank you.
Thank you for that endorsement, Kazuhiro. But I will elaborate just a little bit on the SIAC panel. So, Kazuhiro alluded to our panel of arbitrators. And so, we do have over 500 arbitrators on the panel, and the standards to be included on the panel are quite high. You can read more about it on the SIAC website. And so when SIAC makes an appointment, that is generally the first place that we'll look. But we can also appoint arbitrators that are not on the panel, and we often do when the case calls for it. When there are circumstances in the case that would require special expertise or special background, perhaps in Japanese law, then we can appoint off panel as well. And of course, parties are welcome to appoint anyone that they want. They do not have to nominate people on the panel. They can nominate whoever they want as arbitrators in their case.
Yeah. That's right. I actually forgot to mention one thing, that there is a very important to that whether that the rules of arbitral institution can allow the company to choose arbitrator from the list and outside the list of the arbitrators, especially in case of such 3 arbitral arbitrations. Japanese company choose that the arbitrator from the outside the list of the arbitrator. That in that case, that they can choose that the arbitrator who can understand Japanese culture very well. So that's very important. Yeah.
Absolutely. And real final comment before I turn to Elaine to give her views on this. One of the things about SIAC is that we really do know Asia. We have, Japanese parties are top users of SIAC. We have expertise in appointing arbitrators that are going to be familiar with Japanese legal culture, Japanese business culture, Japanese law, and so forth. But that's all I'll say on that right now. And if I could sort of get Elaine to come in again and just, you have any additional thoughts that you would add to what Kazuhiro said?
Thanks, Michelle. I think it's often said that the appointment of the tribunal is one of the most important decisions to be made in the arbitration. So obviously everyone is concerned to know how best to appoint the arbitrators in their case. I totally agree with Kobayashi Sensei that there are slightly different considerations depending on whether you have a sole arbitrator or a panel of 3 arbitrators. So let me take the latter case first. So when you have 3 arbitrators, what we can do is to balance the qualities of each of the arbitrators, right? So for example, you might want the arbitrators to be familiar with the governing law. You might want the arbitrators to be familiar with the law of the seat of the arbitration, of course. You might want the arbitrators to be familiar with that particular industry that you're dealing with. So maybe it's an issue arising out of the tech industry or the construction industry, or it's an energy, oil and gas project. So you might want someone who knows or is very familiar with issues arising from those particular sectors. Or it could be a particular area of the law that is quite specialist. And so you think, oh, it'd be good if our arbitrators were very familiar with this type of laws, has experience in handling these type of legal issues. And then there are other considerations. For example, do you want a common law arbitrator? Do you want a civil law arbitrator? But I think what we should always keep in mind is that in a panel of 3, your choice only impacts that one person. So you get to choose 1 out of 3, right? But what you need is an award that's in your favor. So you need at least 2 arbitrators to agree with you. So even if your nominated arbitrator is in your mind the best person ever, he knows our company through and through, you know, he's very familiar with whatever our local law or our local language or our local business culture. If that person isn't able to persuade the other 2, you're not going to get an award in your favor. So what we need to do is to balance the qualities of your nominated arbitrator in terms of technical capabilities with that person's standing, perhaps, in the arbitration community. So is this person, you know, it doesn't have to be senior, it doesn't have to be someone who's old. People who are younger can also be very capable and very influential. But is this person someone who garners the respect of his fellow arbitrators? And I say his, but it's his or hers fellow arbitrators. So, you know, it's somebody who, when he or she speaks and expresses views, will the other arbitrators listen and take that into account? Because you don't want your arbitrator to be sidelined. So, you know, he or she says whatever, but the other 2 are a bit skeptical. So, you know, all of these dynamics have to be taken into account. And so we often advise our clients to consider a whole host of factors. We always say, obviously, get someone capable, get someone diligent. So we don't want someone who, to be blunt, is lazy or overworked, right? Some arbitrators are very, very good, but they have too many cases. And so they don't have the ability to give enough time to your case. And you don't want to feel that you haven't had a chance to really put your case forward to someone who's going to listen. So all of those factors need to be taken into account. And then we usually recommend someone who has familiarity with the sector, who's capable, may or may not be qualified in a specific jurisdiction. That's not always a requirement, because, you know, if one of the panel of 3 is qualified in a jurisdiction, maybe that's sufficient. If you're going to call expert witnesses to explain the contents of the governing law, maybe that's sufficient, and you don't need the arbitrator to be actually qualified in that jurisdiction. And then we just want someone that we know will be fair and that will make sure that that person pushes the arbitration along and knows how to deal with the procedure in case, you know, the other party is very uncooperative or creates unnecessary disturbances during the proceedings.
Thanks, Elaine, for that super practical perspective that I think is really important for parties to understand. Does anybody else want to chime in on this topic? I know we are starting to run short on time, but I know it's a very interesting topic for people.
Actually, I do agree with Elaine. I myself actually appointed that the such American arbitrator in case of the American Arbitration Association. For the in case of 3 arbitrators, considering such the issues that the Elaine took, that actually that the arbitrator should consider that the whether he or she can actually persuade that the third party arbitrator that the important thing, and also they know that the rules of the arbitration association, also the governing law, that's right. Yeah. So especially in case of the Japanese arbitrators, they have to they persuade that the other arbitrators in English. So also we have to think of that such a Japanese arbitrator who can speak English very well. Yeah, thank you.
Yeah, the reality is language is an issue as well. Masafumi, did you have something you want to add?
Well, yes, just one thing to add. Sometimes Japanese companies are quite anxious about the discovery So one element might be that whether the potential arbitrator is very pro discovery or kind of restrictive to discovery. That may be sometimes a point for appointing an arbitrator.
Absolutely.
For Japanese companies.
Yeah, I think, especially when you're looking at companies from civil law countries versus common law countries, there's going to be huge differences in expectations with respect to discovery. So definitely an important consideration when choosing arbitrators. All right, the clock is ticking, so let's move on. We're going to now talk about applications that you would make pre-constitution or before the arbitral tribunal is in place. So the first topic is actually interim relief. And I'm going to have to ask Elaine if she could just very briefly, in just a minute or two, just tell us a little bit about, I had wanted to give a more detailed discussion on types of interim relief, but maybe we can just focus on emergency arbitration, what it is and when parties might want to use it.
Yeah, sure. I'm very happy to do this quickly. Emergency arbitration is something offered by the SIAC rules, for example. It's a means by which you can ask the emergency arbitrator to make an order on interim relief. And interim relief basically is a means by which you preserve the subject matter of your case. So because an arbitration takes some time to complete, you may be concerned that the subject matter that you're fighting over may be dissipated, may be lost by the time you get to an award. So you could ask, for example, for an injunction. So that's an order to prevent someone from doing something usually, or perhaps a freezing order. Maybe you want to freeze some monies in a bank or something like that. And so what the procedure in the SIAC rules allow you to do is to call on the panel of emergency arbitrators. You get to appoint someone very quickly. So SIAC will help you with that. I think even if it's a weekend, they'll call up potential candidates and go, hi, you're interested in doing this. They'll get them to clear conflicts. And then they'll tell you very quickly, hey, we've got someone lined up for you. And then that arbitrator puts forward a procedure, discusses with the party. He or she may or may not ask for a hearing. It may just be written submissions. And then they're supposed to issue an emergency award within 14 days. So can you imagine that's very quick, 2 weeks to get some kind of order. And just so that everyone feels comfortable with it, it's not as if you're shortchanged of the opportunity to present your case fully. It's just an interim measure. So when the tribunal is properly constituted, tribunal may decide to modify the award. It may decide that they don't want to follow it, or they can affirm it, of course. So it's just another tool in the box for you to use if you need it.
Right. Perfect quick summary. Okay, now let's talk about jurisdictional objections. I think this is a very interesting topic because you have all sorts of different types of jurisdictional objections. They can have a really big impact on your case. So I will turn to Jill. Jill, could you tell us about jurisdictional objections? What are they? When are they used? What are the implications? Any other information you think that our guests would find interesting?
Well, some of the jurisdictional objections that are often raised, I'll just list a few examples. One of it is that the scope of the arbitration agreement doesn't cover the particular dispute that's before the parties. Maybe it's a dispute that one party says arises under a separate contract instead, or you have arguments that the subject matter of the dispute is not arbitrable, or a common issue also is that there is no valid arbitration agreement between the parties, perhaps because parties never entered into an arbitration agreement, or that one of the parties is not a signatory to the arbitration agreement. So that party says they're not actually bound by that agreement. Another frequent objection, although less so nowadays because of the model clauses that a lot of the arbitral institutions offer, is that clauses are pathological, which means a clause that has language that is so unclear or inconsistent that it is difficult to ascertain an intention by the parties to refer the dispute to arbitration. So, for example, it could refer to some non-existent arbitral institution like the Arbitration Committee of Singapore, or it could refer to the SIAC administering an arbitration under the ICC rules, which a party could say is uncertain or unworkable. So what happens in that event? Well, the clause would have to be interpreted by the arbitral tribunal or the courts reviewing the existence of the arbitration agreement. And generally, especially in the case of Singapore, the courts have sought to give effect to these pathological clauses, preferring some interpretation that would give effect as much as possible to parties' decision to refer the disputes to arbitration. So in the case of, SIAC administering arbitration under ICC rules, past cases have shown that the courts would actually ask parties to approach SIAC to ask whether they'd be willing to administer an arbitration along those lines. So these are, some of the sort of objections that can be raised in the course of the arbitration.
Thank you for that, Jill. And so just quick follow-up question. Let's say you have a jurisdictional, your counterparty raises a jurisdictional objection, arguing that you're in the wrong center or it's a pathological clause, and the tribunal agrees. What happens to your case then? Do you have any recourse? Is your dispute over?
Well, it depends at what stage and how the tribunal makes a ruling on jurisdiction. So if the tribunal makes rules on it as a preliminary question, the party actually has an option of going to the courts to appeal on the issue of jurisdiction. And benefit of that is that the court would look at the jurisdictional ruling de novo, so they would be able to consider it afresh without being bound in any way by the tribunal's ruling. Alternatively, if the ruling on jurisdiction comes together with the ruling on the merits, that is something that the party may look towards setting aside if they consider that the tribunal exceeded its jurisdiction in making that ruling.
Okay, great. Thank you for that. One other thing that you mentioned was non-signatories. The potential objection could be made to the participation of somebody who didn't sign the arbitration agreement. Masafumi, could you tell us a little bit about that scenario and what might happen?
Okay, well, I have increasingly come to handle such non-signatory cases. Typically, well, for instance, the CEO of the company or the parties which signed the arbitration agreement, is also filed an arbitration as respondent. Or in other cases, sometimes like seller and buyer concludes an agreement with arbitration clause. And when the seller is not the manufacturer, buyer may file arbitration against the manufacturer, which did not sign the agreement, including arbitration agreement clause. In such cases, the non-signatory respondent may file the jurisdictional objection, saying that it has not signed any agreement, because arbitration is basically the creature of agreement. And so the simple rule is that no agreement, no arbitration. But the difficult question is that if the arbitration agreement is construed to include such non-signatory to be bound by arbitration agreement, or if the governing law of the arbitration agreement would operate to impose such non-signatory the duty to arbitrate, then that non-signatory might be involved in the arbitration. So I'd like the parties to be aware of such increasing concern and probably be prepared for that. Thank you.
Thank you very much for that. So we've got one more topic left, and then we're going to move on to question and answer. But the topic before we get to Q&A is expedited procedure. Expedited procedure is basically a mechanism that allows you to sort of fast track your arbitration, and it's extremely popular at SIAC and other institutions as well. So maybe I can have Masafumi come back in and tell us a little bit about expedited procedure. We've got a couple minutes left. Just maybe a quick overview of what it is and when parties should think about making use of this fast track mechanism?
Thank you. Well, I have the experience of the expedited procedure, both as counsel and arbitrator, and I have found it an excellent tool to save time and cost. Roughly speaking, you can finish the whole procedure in 6 months. That's a great deal because you can save, of course, time, and because the counsel and arbitrators are paid mostly by hourly rate, so you can save cost as well. I would like to point out maybe 3 features of the expedited procedure. First, how can it be so fast? As the tribunal and the parties are supposed to finish the case in 6 months, the time limit for various submissions is often shorter than in normal cases. Thus, the submissions are likely to be concise. Quite often, discovery will be minimum, expert witness is not called, and the fact witness will be only 1 from each party or even 0. The second point is that how can you use expedited procedure? It depends on the arbitral institution's rules. For instance, SIAC, under SIAC rules, if the disputed amount is 6 million Singapore dollar or around 4.4 million US dollar or less, and the case is not too complicated, then if you apply for expedited procedure, it's likely that it is granted. Under ICC rules, it was 2 million US dollar, and recently they raised up to 3 million US dollar. And JCAA raised from 50 million Japanese yen to 300 million, 6 times recently. Third, what type of case is suitable for expedited procedure? As I explained, arbitration institutions provide that cases within disputed amount below certain level is eligible for expedited procedure. This is because small and middle-sized cases are often not too complex and not worthy of spending time and cost. But there are exceptions. Generally, I'd recommend not to apply for expedited procedure in cases where you need an expert witness, or you need considerable discovery, or there are number of hotly contested issues. Okay, these are the very brief summary of the expedited procedure in the interest of time. Thank you.
Thank you so much, Masafumi. Again, yeah, as he said, very useful tool. Expedited procedure can really help parties save time and cost. It's not going to be the right fit for every case, but when it is the right fit, we do encourage parties to apply and then see if they can get their dispute resolved within the 6-month time frame set out in the rules for expedited procedure. Okay, so we've got about 10 minutes and we've got some interesting questions in the Q&A box. So I'm going to try to get through as many as we can. So I'll just pose them to the panelists and I'll just ask my speakers to try to keep your answers fairly brief if you can, so we can get through as many questions as possible. So our first question is interesting in the particularly in light of COVID-19 and the fact that you're having a lot of hearings taking place over platforms like Zoom and Teams and everything else. And if I'm understanding the question correctly, it's whether parties can choose to have a different law, like a different country's law, apply to any cyber security issues that are going to arise because in an online or a remote hearing. And so, Elaine, is this something that you've dealt with? Is this something that you think parties could or should do?
Yeah, it's an interesting question. I haven't come across such a choice of law. I would be hesitant to recommend it, and I explain why. I'm assuming here that we're concerned about, say, data protection or cybersecurity issues that arise from the actual hearing, right? So because we're conducting it remotely. So I suspect that if anything arises, the law of your seat should probably be able to deal with those issues. if, for example, we are concerned, or if you're very unfortunate and maybe there's a cyber attack, right, on the system, just as you're having the hearing and confidential information is leaked, I think at that stage, it's far more complicated. That's actually a crime. So, you know, different laws and regulations will be breached, and we have to consider a whole bunch of things. So, for example, who's the hacker, where are they conducting the activity, where's the effect felt, who has suffered loss. So actually, the applicable law is probably going to be the result of a very complicated analysis, and I'm not 100% sure that providing a law to govern such issues at the outset before the incident has happened will really help you that much.
Okay, thank you very much for that. And that was an interesting question, and thank you to our audience member that raised that. I will now ask Kazuhiro the next question. And the question that we've been asked is whether you would recommend third-party funding for disputes involving SMEs in Osaka against larger companies abroad. Thoughts on third-party funding, Kazuhiro?
The third-party funding is the issue of third-party funding is not settled in Japan, but I don't think that there is any law which prohibits such third-party funding, like the former Hong Kong law or Singapore law. So I think it's possible, but considering that the third-party funding in case of arbitration, but using the such third funding, that I think we should choose that the arbitral institutions which has the rules for such third funding, you know, in case like Singapore, SIAC or something like that. That's much better, I think.
Great, thank you. Yeah, third-party funding is an interesting topic. SIC does have a practice note on third-party funding, which you know, I encourage you to check out. It is on our website, and I know that it's something we are, you know, generally in the arbitration community starting to see more and more of. So I think that's something to definitely keep an eye on as things develop. So we also have questions directed to the JAA specifically and about the JIDRC's functions. And maybe I'll ask Mr. Masafumi about these, given you're chair of JAA and you also play a role at JIDRC. So if you don't mind, the first question is actually, you know, does JAA have a recommended or a model arbitration clause? You know, are you aware of any cases in which the agreement says that the case would be arbitrated in Japan, whether in Osaka or in Tokyo, and with Japanese laws to apply? And then the second question about JIDRC is JIDRC an arbitral institution, or is it just a hearing facility? Is it like Maxwell Chambers? What is JIDRC?
Thank you very much for the question. Well, JDLC is primarily a hearing facility like Maxwell Chambers. But in the meantime, JDLC is now entrusted by the Japanese government to promote arbitration, especially in Japan. So we are hosting or supporting various seminars all around the world and trying to have the training opportunity as well in cooperation with other institutions. So that means that JDLC or JAA is not the arbitral institution like SIAC or JCAA. In Japan, the representative arbitral institution is JCAA, Japan Commercial Arbitration Association. And if you go to JCAA website, then you can find a model arbitration clause, including the seat in Japan. Thank you.
Great. Thank you for that. Do you want to go ahead? Go ahead.
JAA doesn't have such a model arbitration clause, but Japan International Mediation Center has a model mediation clause, which can, you know, used for any arbitral institution. So you can check that the GMIC website too.
Great. Yeah, that's important. Thank you.
Thank you both. So I think we've got time for one more question, and I would like to pose this to Jill. How important is it for an arbitrator to be familiar with the governing law of the contract and or the governing law of the seat? I think Elaine touched on this earlier, but maybe you can elaborate a little bit more on that.
I think actually in my experience, it's not critical for the arbitrator to be familiar either with the governing law of the contract or of the seat. I've had experiences of tribunals who are not of the jurisdiction that is either law of the contract or law of the seat. But between the two, it probably would be a bit more important to nominate somebody who is familiar with at least the governing law of the contract, less so with the law of the seat, because that probably only comes in when we look towards the courts for any measures to assist in the arbitration or at the setting aside stage. So between the two, I would say more important for someone to be familiar with the governing law of the contract.
Great, thank you for that. Okay, we've got a couple more minutes, which is great because we still have some really excellent questions. So one question that came up, which is fascinating, is, what is the impact? Well, let me provide some context. So in the arbitration community, there have been some developments to, try to use try to use AI or other types of resources to gain some knowledge about arbitrators, and then hopefully parties can potentially use that in making their selections for arbitrator appointments. And so the question here is, if I don't, maybe Elaine can answer this, or anybody feel free to jump in. How do you sort of perceive the impact of these kinds of developments, like arbitrator intelligence and other sort of efforts to collate information about arbitrators and use that in the appointment of arbitrators in live cases?
I don't have a direct experience using this, so I won't belabor the point for too long. All I would say is that, of course, it is important to try and collate information about the potential arbitrators, and we do that very often by perhaps, like within our firm, we have a database of all our appointments. We get feedback whether or not we thought someone was, acted fairly or put in a lot of effort and issued an award that was sensible and enforceable. So that it is already useful, and I think it's important for us to discuss as an arbitration community and share ideas. If the idea is that we want to track the type of awards or nature or thoughts of that person, so whether or not they've written literature about this particular topic, so that we can predict where the arbitrator might go on a certain issue, I am less convinced of the utility of that. But I'm very happy to hear about the experiences of others. Anybody else have thoughts on these developments?
I think probably one way it would be useful is to give, some insight on arbitrators that are lesser appointed, what someone's not very familiar with. These tools can introduce you to new arbitrators. But personally as well, same as Elaine, I don't have that much experience with it.
Sure. Kazuhiro?
I think that I agree with that the AI is increasing rapidly, but I doubt that because of the confidential nature of arbitration, I don't think it's not worthwhile right now using AI for appointing an arbitrator or something like that.
Okay. Well, I think that we'll sort of wrap up on that note, sort of looking out into the future to see, what the impact of these types of initiatives will be. But for now, that is all the time that we have. So I would like to thank our panelists for joining us today and giving us some really important and practical advice and insights into the considerations parties should be thinking about when they're drafting their arbitration agreements, when they're entering into settlement discussions, when they're just starting out with their arbitration. So thank you all for being here today, and thank you to our attendees for joining us and for asking such insightful questions. It's been a pleasure. Please do join us for future SIAC and JAA events and initiatives. Take care, and we'll see you all soon.
Thank you very much. Goodbye.
Thanks so much.
Bye-bye.
Thank you.
Bye.
Bye.
Bye.